really lovely to chat with you. We just enjoyed a really lovely session on modification of awards, and we loved what you had to say. I just thought I'll pick your brain on a couple of points. The first thing I'd like to probably draw from what we were speaking right now, in terms of finality and fairness, and we heard what you had to say, but if you can add something on what you believe is a line to draw and what India can learn from that, I think it'd be great.
Well, I think it gets at a fundamental question at the heart of international arbitration. What is this process? And it seems to me there are alternatives that make available substantive review. Courts provide for appeal. And it may be that we're better looking to those alternatives than to international arbitration if what parties want is substantive rights of appeal. That having been said, I think we should think creatively about building in rights of appeal where parties want them in institutional arbitration. There's no reason why one couldn't agree for an institutional appeal. Arbitration under the rules of X is possible to appeal within the confines of that international arbitration institution. It seems to me that thinking creatively, broadly about those sorts of alternatives is where we ought go, rather than, I think, this potentially uncomfortable, risky melange where you have the judiciary trying to correct perceived errors within the universe of international arbitration, which is, to a greater or lesser extent, a self-contained universe directed at finality.
No, that's lovely. Because of what you just said about institutional rules, to prefer that which is preferred over judicial intervention, and you've had a wide range of experience appearing for most of these institutions. So, do you think something from that, any procedure or rule that can help? If everybody were to follow this particular procedure, it'll help the process better?
Well, I certainly think that one of the things that's particular about the Indian experience, as I understand it, is the dominance of ad hoc arbitration, which is unusual elsewhere in the world. And one of the points I made in the panel was I worry about the limits of that analog from elsewhere, from places where ad hoc arbitration is much, much, much less common. And so I think this ad hoc institutional distinction is a really important one. And perhaps before you even get to any particular rules, a growth in the employment of institutional arbitration with some of the guardrails that provides would be a step forward.
That's amazing. In fact, one of the aims of NPAC is to promote institutional arbitration. While we are one such institute, even we see the advent of ad hoc way more than institutional arbitration. So that as a culture, I think that change itself could bring in a good first step of momentum. And from there, maybe we can imbibe best practices from organizations. Would you say
yes, I think that's right. And I really think the rarity of ad hoc arbitration outside of India is quite stark, and I think comes as a surprise to those who have developed deep Indian practices focused on ad hoc arbitration. In my career, I've argued a lot of ad hoc investment cases, investment treaty cases, but ad hoc commercial cases, I could count on, I was going to say one hand, I mean I could count on a couple of fingers, really. It's a rarity.
Definitely. And I think, just as a comment, even the way clauses are drafted or contracts are made, I think there has to be a shift to introducing arbitration through institutional arbitration, because I think everybody just defaults to ad hoc. So I think that's a very good point. But again, to draw from what you were saying, because of your wide range of experience, there's a case to be made for uniformity versus local realities as well. For example, here, whether it's a best case scenario or not, ad hoc is a reality today.
Yes.
So in terms of reforms, because one theme today is reform, so would you argue for uniformity across jurisdictions, or do you think there's merit in flexibility for local realities?
My answer is yes.
An example in each case could serve.
One of the questions that was put to me in the panel just now was whether the Singapore example of bifurcated regime between domestic arbitration and international arbitration is a model that could be adopted in India. And I think the answer to that is maybe.
Okay.
In that if you had a unique domestic model, it could meet some of those local realities that you're describing. One of the points that was made on the panel is it is hard for a judge to divide her mind and say, this is a domestic case and that's an international case, and I adopt a fundamentally different approach across the two. And I think that's right.
Disputes at the end of the day. So to completely sideline both.
Divorce oneself.
Correct.
That having been said, judges are called upon to do precisely that in all sorts of contexts, say this is the regime applicable to this case. So I think it certainly warrants reflection on whether that bifurcation as between domestic arbitration and international arbitration might be one route.
Okay. The other theme today was on digitisation. So given that a lot of AI tools and online arbitrations become prevalent, do you see where we can ensure it's efficient but also ensure there's evidence integrity?
Yes, I mean, it's a fundamentally important question. It's not only a question of integrity of evidence, it's also integrity of submission.
Correct.
I'm dealing with a case at the moment. I won't say the legal system. It's not Indian, nor is it a common law system. It's a civil law system where our opponents have, I am convinced, hallucinated citations to court decisions from that civil law system. I say they've hallucinated. The AI tool they have used has hallucinated. I don't pin it on the individual counsel opposite. So I think it's not only a question of evidence, but also, as we all know, of submission. I think clearly all of us need to be able to use a sophisticated array of AI tools. I say all of us, both counsel and arbitrators, but ultimately take responsibility. I mean, isn't that really what it's about? If I sign a submission to an arbitral tribunal, I'm putting my name on it, I need to stand behind it, and I may well have, and my colleagues may well have used AI tools in developing it, just as an arbitrator may well be assisted by AI tools, but it has to be her decision at the end of the day. The buck has to stop somewhere, and I think we don't want to lose sight of that responsibility each of us as counsel or arbitrator has in the process.
I think someone mentioned, as you were saying, it's not only with respect to evidence. Someone was mentioning earlier today that the arbitrator used AI to prepare the award as well. So we don't know where this stops. But apart from what you're saying in terms of human restraint, do you believe there could be a procedural safeguard to begin with to sort of measure this a bit?
Yes, I mean, certainly think it's appropriate in the context of procedural order number 1 to have a discussion around whether limits on AI use are appropriate. So, for example, at the lowest level, a stipulation in procedural order number 1, assuming the arbitration is confidential, as will often be the case, that non-proprietary AI tools not be used. In other words, that submissions don't get fed into the online version of GPT, for example, but that only those that are walled off and confidential, where confidentiality is protected, are used. So that seems to me a pretty simple step, but a safeguard that at least ought to be debated in the context of procedural order number 1.
Just 2 more questions. You were talking about confidentiality. So even last year, Justice Pratibha was here, and I think today she mentioned this again about having or developing data repositories for arbitration. So given confidentiality and the need for transparency, that was also highlighted by Justice Philip. What is your view on how we can get started but balance everything?
Well, it takes time. At the lowest level, as Justice Jayaratham said, the process of redaction, anonymization of awards takes time. I'm not sure there's a great deal we can do about that, though AI will make that faster. I don't think it changes the category of the problem. It makes it faster. But I think that's the right approach. I think arbitral institutions should continue to push towards publication of appropriately anonymized awards. Now, I say that in the context of commercial disputes. My own view in the context of investment treaty disputes is, of course, it depends on the terms of the relevant treaty, and one must be guided by the terms of that treaty and the applicable rules. But taking a step up, a higher level of abstraction in investment treaty cases, it seems to me the right policy setting is one of transparency. Now, obviously, different treaties, different rules provide for different outcomes as agreed between the states parties. But at a policy matter, those are cases of public interest and public importance. And I think transparency is more clearly the right answer there. In commercial cases, I think it's a more nuanced analysis. But clearly, redaction, anonymization, and publication of redacted, anonymized awards is a step in the right direction. I think the ICC has been leading the charge on that. I would like to see other institutions follow suit.
That's lovely. I think it's high time we probably start exploring this, and it is, like you said, going to take a lot of time. But that apart, I think it is probably high time we get started on at least the first step on creating this repository of sorts, so we can work on publication while we work. While I think it is also intrinsically important to ensure this redaction and all of that is maintained, because otherwise it loses its integrity.
Well, and I would suggest in some ways we're in this uncomfortable no person's land, because once you start to scratch the surface, there are more quote unquote confidential awards that have entered the public domain than one might expect. There are pretty good, albeit expensive, databases available through which those that have access to them might research for confidential awards, because they've been simply because they've been leaked in some cases, but they may have entered the public domain by way of challenge or enforcement or recognition proceedings in unexpected jurisdictions someplace around the world. And so those are available, but available with a small a. You sort of have to know where to look. They're not systematically available.
I was going to only have one more, but because you said, look at Justice Jayaratnam was talking about the pair search. So anything based on this?
No, save to say I think it's clearly a step in the right direction.
Perfect.
And we shall see, I think.
That's wonderful. The last question I had was, do you believe there's one underrated quality that clients look for in arbitrators and counsels? We have the usual impartiality and all of that, but based on your experience.
I will answer it with respect to arbitrators, because I am principally counsel, and so others can judge service as counsel. But as a consumer of arbitrators, I think it is simply this: doing the job. What I want is an arbitrator who will read the papers, consider the evidence and the submissions, and have an open mind as she consumes the evidence and the submissions. And that is not about being predisposed to my view or my client's view. It's simply engaging with the papers and oral submissions and evidence. And of course, the bulk of arbitrators do that, but in reality, not all do. I want a prepared arbitrator who has done the reading and turns her mind to the issues in the case, an open mind.
That's very good. I think that's almost as if go back to the basics instead of coming up with an exotic or innovative term. Do your job.
Do the job, exactly so.
I think that's a good way to put it. But yeah, I think those were mainly the points that I wanted to speak to you about.
Thank you very much.
Thank you so much for your time.
Of course. Thank you.